Fraudulent Conveyances Act 1571. The Fraudulent Conveyances Act 1571 13 Eliz 1, c5, also known as the Statute of 13 Elizabeth, was an Act of Parliament in England. In the United Kingdom, the provisions contained in the 1571 Act were replaced by Part Roman 9 of the Law of Property Act 1925, which has since been replaced by Part Roman 16 of the Insolvency Act 1986. Text: for the avoiding of feigned, covenous, and fraudulent fiefments, gifts, grants, alienations, bonds, suits, judgments, and executions, as well of lands and in tenements, as of goods and chattels, more commonly used and practised in these days than hath been seen or heard of heretofore, which fiefments, gifts, grants, etc. have been and are devised and contrived of malice, fraud, covin, collusion, or guile to the end, purpose, and intent to delay, hinder, or defraud creditors. Be it therefore declared, ordained, and enacted, that all and every fiefment, gift, grant, alienation, bargain, and conveyance of lands, tenements, hereditaments, goods, and chattels, or any of them, by writing or otherwise, and all and every bond, suit, judgment, and execution at any time, had or made to or for any intent or purpose before declared and expressed, provided that this act or anything therein contained shall not extend to any estate or interest in land, tenements, hereditaments, leases, rents, commons, profits, goods or chattels, had, made, conveyed or assured, or hereafter to be had, made, conveyed or assured, which estate or interest is or shall be, upon good consideration and bona fide, lawfully conveyed or assured to any person or persons, or bodies politic or corporate, not. It is clear from the text of the statute that it was framed in a purposive manner. So if someone had the intention of defrauding a creditor, unless a transaction was made bona fide and for good consideration, it would be void. Historical background: in 1571, Parliament enacted this statute to prohibit transfers intended to defraud creditors or impede their collection efforts. This statute, known as the Statute of 13 Elizabeth, was passed in response to the widespread use of fraudulent transactions to defeat creditors. Until the 1600s, England had numerous sanctuaries not subject to the King's writ. These sanctuaries included churches, but also certain areas defined by custom or royal grant. Debtors would often sell their property to friends or family at unreasonably low prices with the promise of buying it back later, move to a sanctuary, and then wait for creditors to exhaust their efforts or offer a favorable settlement. Cases under the Act: Alderson v. Temple 1768, 1746, 1779, 1 Black W. 660, 96 ER 384. Lord Mansfield held the Act applied, not just to fraudulent conveyances, but also the granting of fraudulent preferences. He said a fraudulent preference by a debtor, if made on the eve of, and followed by, the bankruptcy of the debtor, has been void against his creditors, because it aims at preventing that equal distribution of assets among the creditors, which has always been the object of those laws. Twins Case 16013 Coke Atib, 76 ER 809 held that where a debtor tried to transfer title to property to another party but retained possession of it, that was repugnant to the Act. Ideal Bedding v. Holland 1907 2 ch. 157, where Kekuich J. noted that by virtue of subsequent enactments widening the potential relief available to creditors, the Act had come to apply in a wide variety of circumstances which seemed to wider than the original intended application, as there was more potential for an action to constitute a hindrance upon that entitlement to relief. Trustee of the property of Payson, a bankrupt v. Von Greyers 1999, 4 LRC 135. In one of the most recent appellate decisions on the Act, the Privy Council heard an appeal relating to the Act from Gibraltar, where the Act still applies. Other jurisdictions: United States. Many U.S. states enacted their own versions of the Statute of 13 Elizabeth after the American Revolution. The Act was later superseded by the Uniform Fraudulent Conveyances Act of 1918 UFCA, which in turn was superseded by the Uniform Fraudulent Transfer Act of 1984 UFTA. To date, UFTA has been enacted in 43 states and the District of Columbia. Both the Bankruptcy Act of 1938 and the Bankruptcy Reform Act of 1978 also included their own versions of the UFCA. Commonwealth. The laws of England were incorporated into numerous of the colonies on specified dates. In Western Canada, for example, the laws of England were incorporated as the laws of the Northwest Territories, now Saskatchewan, Alberta, the Northwest Territories, and Nunavut as at 1885. Although most former colonies have passed similar legislation, the 1571 Act may still be in effect in some jurisdictions.